All right, we started the recording. Hello, everybody. Welcome to another session of Lunch and Learn with Geo. If you don't know, I'm Geo. We try to do this on a monthly basis. We've got some interesting topics. Today's real timely. We're going to talk about what's happening with the federal government's enforcement of the immigration laws, or the Gestapo, whatever. I'm going to try to make no political comments about this. So we'll try to keep it clean. We've got two good speakers. Um, by way of introduction, we are recording. So be careful what you say, because it's going to go on the permanent record. We're going to try to post this on YouTube when we're on the NWSBA website and on YouTube. If you've got any questions, please use the chat box, not bot. This is the hashtag I'd like you to use if you're going to post anything on social. Future webinars, I got April 9th. Actually, it's January 14th, I think it is. We're going to talk about cryptocurrency. I didn't change this. This is an old one. But then we've got another one in January 28th on restrictive covenants and employment agreements. Then in February, we're going to go back to AI. We're going to have setting up your law office using AI. And we're also going to do an ethics presentation on using AI. If you're a member of the NWSBA, you get free CLE credit here. We'll give you instructions on how to get it later. You're here today because you're supposed to get educated and stay educated. But more importantly, I always try to keep you up to date with technology. As most of you guys know who know me well, I've been a proponent of using technology in the practice for a long time. But primarily that's why we're here. And right now, it's becoming even more important because technology is becoming more and more important in our practice. I'd like to introduce you to our speakers. Jerry Barrera, his firm does nothing but immigration. They've got, I don't know, I'm not going to ask Jerry, but I know you've got a lot of paralegals who are multilingual, handling all kinds of immigration issues. And they do a really good job of it. Adam Berger is a member of the NWSBA. You're on the board, aren't you, Adam?
I am.
Well, how about that? We finally got a board member to participate in this thing. You could spread the word at the next board meeting that George is disappointed. Geo is disappointed in the board's attendance. But Adam has primarily a business practice and is going to talk to us about the business owner's perspective on what's happening with the ICE raids. So with that, I'm going to turn it over and let Jerry take over and share his screen.
Absolutely. Thank you, George. And yes, hello, everyone. My name is Jerry Barrera. I practice solely immigration law. I was admitted in 2016 and have been doing that ever since. So I'm going to go ahead and share my screen here because I prepared a PowerPoint presentation to discuss the topic of ICE raids. So let's see. Get that up.
Very good, Jerry. I'm proud of your technology here.
I'm learning. I'm learning. Okay, so ICE and also CBP raids. ICE, we commonly understand these raids to involve ICE, but CBP recently has also entered the fold in these raids. So I'll focus it more on the immigration lawyer's perspective. And I'll talk a little bit about who the players are, ICE and CBP. ICE raids in general, are they constitutional? Where the authority comes from for these ICE raids? Legal rights during an encounter with ICE, both during and after an arrest. And then also how I'll touch a little bit about immigration court. I'm not going to spend too much time on that, only because that's a whole separate presentation. I can spend, an hour on that, but we'll talk a little bit about the legal rights during detention and during these arrests, and then we'll finish up by talking about um, Operation Midway Blitz. Operation Midway Blitz was a series of ICE raids that were uh, targeting the Chicagoland area. So I know this garnered a lot of attention in the news during October and November. So it was almost 2 months that they were stationed here. And then, yeah, if anybody has any questions, feel free to jump on the chat and ask questions. Gio, you mentioned you would handle the chat.
Yes, anybody
Okay,
has questions on the chat, I'll let you know.
very good. So ICE versus CBP, we should know both of these are agencies within the Department of Homeland Security. ICE focuses more on apprehending, detaining, deporting immigrants who are within the U.S., inside of the borders, while CBP is tasked with securing our borders and conducting patrol near our land borders, air borders, or airports and sea borders. So those are the two players. And we're going to talk about what an ICE raid is. These are targeted operations, usually in communities with a high percentage of immigrants. ICE typically arrives unannounced, usually armed and masked, indicating that they have a warrant. But most of the time, they don't actually have a warrant that necessitates an arrest. They typically do that to instill fear, but a lot of times it's not a valid warrant to conduct an arrest. They typically occur at workplaces and homes. However, most recently, they've also been done through what they call roving patrols, where they just patrol the streets out in public. Usually, they send out teams of agents in SUVs to conduct random traffic stops. Again, they'll say that these stops are constitutional and lawful. However, that's highly questionable. They also have been occurring at small businesses, grocery stores, for example, car washes, outdoor work sites, home improvement stores such as Home Depot, Menards, and gas stations. The way it works is ICE out in public, ICE usually approaches individuals, usually based on the color of their skin or their race, a lack of English language skills. If someone has an accent, that usually is a way for them to approach and initiate a conversation with an individual. Almost all of these detentions and arrests are warrantless, despite what the Department of Homeland Security may be putting out in public. Most of them are warrantless. And the goal of an ICE raid is to round up as many people as possible at a location, arrest them, typically and then send them to detention facilities, pressure them to sign away their rights so that they can agree to be sent home through what's called a voluntary departure. Basically, they're made false promises saying, "Oh, well, if you sign this, we'll send you back. You're not going to be subject to any criminal penalties, and you still may have an opportunity to come back in a few years." That's, of course, a lie. If you're here unlawfully and you leave the country, you're automatically subject to a 10-year penalty before you can come back.
Hey, Jerry,
Meaning you have to be
has
outside for 10
anybody,
years. Go ahead.
Jerry, has anybody challenged the constitutionality of these arrests?
They have. So there's multiple lawsuits going around in the district court and also out of California. And I'll touch on that later on. And it usually centers around bond hearings and also how these arrests, how these arrests are initiated. So there was recently a Supreme Court case that was put on the emergency docket, and I have it in my PowerPoint. It was Nome. Here, I can fast.
No, that's all right. You can get to it. Since
No,
you
just so
mentioned
I
the
have the name.
constitutionality of it.
Yeah, just so I have the name. Let's see. Right here. Noam V. Vasquez Perdomo. So is that actually the next slide? Yeah, that's actually the next slide. So
Okay.
perfect segue. To answer the question, yes. So Supreme Court recently held that ICE can make stops based on the following four factors, right? The apparent race or ethnicity of the detainee, whether the detained individual speaks Spanish or English with an accent, the type of location where they are found, such as a car wash or bus stops, and the type of job they appear to work. I don't know, but that sounds a lot like racial profiling. Well, the Supreme Court said that they can use these factors to make these stops.
Well, under these factors, any Greek who owns a restaurant may be a problem then, huh?
Yeah, there you go. Exactly. Then just to touch base on the legal authority for these raids, so they come from the Immigration and Nationality Act. There's a provision in there that states that any alien or person believed to be in the country illegally has immigration officers have a right to question them. The Supreme Court case, the United States v. Brignani Ponce, also indicated that immigration officers may briefly detain an individual to question them regarding their legal status if they have reasonable suspicion based on articulable facts that the person being questioned is here illegally. And I guess recently the Supreme Court says that those four factors are articulable facts. So that's the legal authority for these raids. We'll move on now. So talk about rights when approached by ICE. So you have a right to remain silent. You don't have to talk to immigration officers. Typically, when clients come and see me and ask, what to do when they're approached by ICE, I always tell them, you don't have to talk to them. Don't discuss your legal status with them unless you are here legally. Then you can just show them your legal paperwork, your citizenship documents or permanent resident documents, and you're free to go. After that, they should ask if they're free to go. However, that's almost never how it plays out in practice. They're never going to let you go. They're going to pressure you to answer questions. And if they don't get any answers, they'll most likely arrest you and take you in for further questioning. You have a right to refuse any searches. If you're arrested, you have a right to a lawyer. You also have a right to a lawyer during any questioning by these immigration officers. And you can contact the lawyer while you're detained. If ICE comes to your home, you do not have to open the door. Okay. A lot of times, and I touched on this earlier, a lot of times their strategy is they'll present what they call ICE warrants and tell homeowners that they do have a warrant. But the law says that in order to enter the home, they need a judicial warrant that's signed by a judge, either a search or an arrest warrant. And homeowners, individuals typically don't understand this, so they think that that the warrant that they may have or documentation that they may have or whatever paperwork they present is enough, and they open a door. But no, it has to be a warrant that is signed by a judge. Otherwise, they have no authority to come into your home. Okay, so
Have you seen any cases or situations where they actually have a judicial warrant?
very rare. I haven't personally come across any, but from my understanding, it's rare.
You would think if they're going after known gang members, then they
Yeah,
at least for those that are known gang members, they have
yeah,
a judicial warrant.
no,
Not,
no. I don't know if it's because of just maybe the logistics or the difficulty of obtaining them on their end, as opposed to maybe a police officer, if that plays a role into it. But it's rare that ICE has an actual judicial warrant. It could be also agency to agency. Maybe that's something more for the DEA or FBI. But it's rare when ICE or CBP has an actual judicial warrant.
you think?
Um,
Do you think they're generally targeting? They're supposed to target criminals.
yeah.
Um, do you see any targeting of people that are criminals, or is it just a general sweep?
Did you see my PowerPoint ahead of time? Because this is actually something that I was going to touch on as it relates to
Okay.
the Operation Midway Blitz. To answer the question now, no. So the whole Operation Midway Blitz, that was the way they structured it and the way they announced it is, oh, we're going to come into Chicago and we're going to eliminate and arrest and send back all the criminals, the rapists, the gang members, the drug traffickers. Um, a month later, when they're being asked to go to court, Department of Justice documents show that less than 3% of the people arrested uh, had criminal records.
3%.
Less, I think it was 2.6 to be exact. I mean,
Wow.
these are DOJ records submitted in Northern District, showing that out of all the people arrested through these raids, less than 3% of them had criminal records. So, so much for going after all those gang members and criminals. Um, and I'll touch on that a little later. So, what happens after an ICE arrest? They arrive through a raid, they detain someone, they take them in to a detention facility for processing. We always advise do not sign anything without talking to a lawyer first. This is what I was getting at earlier. They typically try to get you to sign, usually a voluntary departure, so that way you can go home without exploring any rights. A lot of these individuals actually have not only rights to a lawyer, a right to a bond hearing, and then later potentially some relief in immigration court. So they're interviewed, asked to sign a voluntary departure. We always say do not do that until you talk to an attorney. Um, if someone has a deportation order that's outstanding, that's somebody who was deported but either never left or they were deported and came back into the country, then those individuals are not entitled to a hearing before an immigration judge. Those individuals are going to be removed through a process that's called reinstatement of removal. That's within the Immigration and Nationality Act. Also, if you've been in the country for less than 2 years, you don't have a right to a hearing before an immigration judge. Those individuals are subject to removal through a process called expedited removal. Um, so, what options does someone have after they're arrested? They don't sign a voluntary departure. Um, they're issued what's called a notice to appear. This is essentially the charging document in the immigration world. They're issued a notice to appear, placed in deportation proceedings, which is a deportation court, and given a future court date in front of an immigration judge. Now what? You're detained, you have a court date. Do you have a right to bond? So this is something that also garnered a lot of attention in the immigration world over the last few months. One, you do have a right to an attorney at your own cost. Um, as it relates to a bond hearing, within the Immigration and Nationality Act, you do have a right to a bond hearing as long as you don't have any extensive criminal history. Um, no certain felonies disqualify you from having a bond hearing. Even certain misdemeanors, usually drug related, violent offenses that may disqualify you from a bond hearing. It just depends on each type of conviction, state to state. So, I don't want to get into too much detail there because it's really case by case on which types of criminal convictions disqualify somebody from bond hearing or not. But the statute says you have a right to a bond hearing. This was the case all the way up until September of this year, where a Board of Immigration Appeals judge held that immigration judges do not have jurisdiction to conduct a bond hearing for people who came into the country unlawfully. That's essentially 80% of the people who are here unlawfully. So that means all of these individuals who were detained recently through either in Los Angeles or Chicago, all of a sudden don't have a right to a bond hearing. So they're detained. I mean, a lot of them still are detained. However, recently, I believe it was a few weeks ago, there was a federal district court in California that came out and overturned that decision. And that judge has now ordered that immigration judges begin conducting bond hearings again. However, we think, and this is most likely what's going to happen, is that's going to be appealed and then stayed, and then we're back to square one. So right now we have a few individuals who we're representing who are detained, and we're pressuring the courts to issue a hearing for a bond. However, by the time we get to that hearing, it's possible that this district court decision in California is appealed and a stay is issued. So that's where we stand in terms of bond. As of right now, there is a right to a bond, assuming no extensive criminal history. You're released on bond, and then it's like criminal bond. You're able to be out in public and while you're waiting your proceedings to go on.
What is the position of the district court here in Chicago on this?
Well, so the district court in California issued a nationwide injunction on the Board of Immigration Appeals case. Um, District Court here in Chicago, based on their recent rulings, they're on board with giving bond hearings. But that decision applies nationwide. So even if there's a district court somewhere else in Texas, for example, they have to follow that decision based out of district court in California.
until, until the U.S. Supreme Court abolishes nationwide injunctions.
Yeah. They'll put a stay on it. This is exactly what happened with the case I was talking about earlier.
Okay.
So what if a judge is unwilling to give a bond hearing? The last line of defense is a habeas corpus petition in the federal district court challenging the constitutionality of the either arrest or detention. So this is actually something that's been common here in Chicago because there's a federal district court decision. Judge Cummings um, issued a decree saying that any individual who was arrested without any probable cause should have a bond hearing. But of course, they weren't following that, and that remains to be the case. And that's also something that they appealed. And the judge about a month ago, indicated that all of the individuals detained, there was a little over 600, should be released or at the very least be given a bond hearing. Well, that was appealed and of course stayed. I'm not going to spend too much time on this, but what are the common ways to fight a deportation court case? So you're released on bond, or even if you're not, you're still eligible to fight the case if you're eligible. But assuming you're released on bond, then when you go to court, there's ways you can fight off the deportation. They call these forms of relief. Cancellation of removal is one of the most important ones and one of the most common ones. Cancellation of removal basically state the requirements are that you've lived here for at least 10 years continuously, uh, that you've had good moral character within those 10 years. One or two arrests typically don't disqualify you. Again, depends case by case, but just establishing good moral character over the last 10 years. And then the third requirement is showing exceptional and extremely unusual hardship to certain family members. Those family members are minor children, parents, or a spouse who have either citizenship or legal permanent residence here in the U.S. Um, so that's one form of relief. Asylum as well. I know asylum is a hot topic, especially over the last few years. These are actually very difficult to get approved. People can submit them, and usually they take about 3 to 5 years to process. But in terms of the outcome, most of them are denied. I think the approval rate, I mean, it varies, but it's usually between 25% to 40%. Adjustment of status just means somebody applying directly for their green card, typically through a family member or an employer as well. Humanitarian relief, TPS, is something that has been used. TPS was something that was popular here recently, especially with Ukraine. These are individuals from countries who are fleeing due to strife in their home country. So Ukraine, obviously the war, and then some years ago there was Honduras and El Salvador who were fleeing due to Hurricane Mitch. Um, that's TPS. It's awarded to certain countries. DACA, that's also relevant. That's more of my age group. Deferred action for childhood arrivals, individuals who arrived into the country at a young age, went to school here, obtained a high school diploma or a GED, and have not otherwise had any disqualifying criminal history. If you have that, you're eligible to get your case thrown out in immigration court. And then U visa, victims of crimes. If you have a U visa, you're protected here. You're here lawfully. They can close out the immigration court case. And then prosecutorial discretion, they won't give that right now, but that's something based on administration to administration, something that you can request. Maybe you don't have any forms of relief, but if overall you don't have a criminal record, you're a decent human being, you have a history of working and at least paying taxes here, they may entertain this option. So those are the ways you can fight off a deportation court case. And now we'll talk about these raids that occurred here in the Chicagoland area. This was termed Operation Midway Blitz. These were ICE and CBP raids in October and November of 2025. And as George was pointing out earlier, they said that they were going to target the worst of the worst, gang members, kidnappers, rapists, drug traffickers. Over 600 individuals detained, less than 3% of them had criminal records. Almost all of these arrests were warrantless. Most individuals were picked up in public places, small businesses, gas stations, on the street, work sites, through unlawful traffic stops. We've all, I don't know about everyone in the chat room, but this garnered a lot of attention in the media. And I mean, there's videos all over social media, YouTube, of how aggressive these agents were while these raids were going on, not only with people that they were pursuing, but also protesters. Um, the next slide, I talk a little bit about that, where tear gas was deployed, even affecting some Chicago police officers. Tear gas deployed near schools. I believe there was a few instances of minor children being affected. There were several shootings. There were guns pointed at bystanders while they were carrying out these operations. Unlawful use of force, multiple lawsuits filed in the district court. It was a situation that I don't think, at least in my time, has never happened in Chicago. Uh, a lot of these individuals that were, well, almost all of them were not issued a bond hearing. Many of them are still detained, and that's something that's ongoing, as I was talking about earlier. They resulted in significant constitutional violations, lack of due process, unreasonable searches, seizures, warrantless arrests, and really just approaching anyone based on the color of their skin and initiating contact. Even U.S. citizens were unlawfully detained and arrested. So this caused a lot of disruption in the community. You essentially have these agents walking around in military gear with rifles, patrolling neighborhoods, community neighborhoods, near schools, near businesses. It just makes for a disastrous outcome, and that's exactly what it was. What it was. A lot of small businesses suffered because people were afraid to go out. Parents are afraid to go out because they're afraid that they may encounter one of these agents. So that means they're not taking their children to school. So that garnered a lot of attention, and there's multiple lawsuits. And Governor Pritzker, I know, is I think George was touching on this earlier, passed legislation, I believe, earlier this week that punishes these ICE agents if,
Well, it gives,
if there's an awful use of force against a protester. Yeah.
I put the language of the statute in the chat box, but it gives somebody whose rights have been violated under the Illinois or U.S. Constitution a right to sue those law enforcement officers. So it gives them a private right of action. I haven't seen any lawsuits yet, but I'm sure there's going to be a spate of them coming up. Maybe Jerry, you and I could work something out for referrals.
Yeah.
So there is legislation that's been passed about that.
Yeah, and I think that's going to continue. I think there's going to be a lot of that, and I think a lot of these individuals are going to have to, well, these ICE agents are going to have to answer personally. Obviously, we don't know a lot of them. We don't know who they are because they were masked and they were not showing any kind of identification. But I think over time, a lot of them will be called in to answer for some of their conduct because it was quite egregious and the lack of training showed. So that's Operation Midway Blitz. Any questions? Anything else you want me to address with? I know there's so much you can talk about with this, but just it was incredible to see. I don't think we've seen anything like it here in Chicago.
You're right. It's very unusual. Okay, thank you, Jerry. You want to stop sharing?
Yeah, and then the last slide I had, it was just ICE raids and the impact on communities, but I kind of went over that already. Just authoritarian style of policing, very chaotic, creates fear for everyone, even including U.S. citizens. So,
are schools doing anything to protect their students in the building? Of course. right?
Well, that legislation that Pritzker announced, uh, I believe what I saw was it it mandates schools to come up with a plan. Schools, daycare centers. I'm not sure what other types of organizations, but schools and daycare centers, it mandates them to come up with a plan in case ICE agents arrive at the school or daycare.
Well, I know the courts are doing that. I know in the third district, the chief judge ordered nobody harass anybody in the building or on the facilities, but they still can hang out in the parking lot and pick people off. So it's really unfortunate. Thanks, Jerry. Adam,
Of course.
you're up.
All right.
All right.
So not only can interaction with an ICE agent be scary for the person that is being targeted, but it can also be very scary and disruptive for an employer or a business when these folks show up. And while Jerry covered pretty much, it was a very comprehensive and tremendous overview of the situation. What I'm trying to do here is provide a little bit of guidance for the business owner so that in the event that something were to happen and you get that proverbial knock at the door, this is what I would recommend that you do.
But Adam, if I could interrupt, Adams is having some handouts posted in the chat box. So if you check out the chat box for the handouts, you'll be able to download them for
Yeah,
your.
and I'll refer to them in my talk. I'll let you know which one to look at. They're basically examples of documents that you may be presented with when ICE shows up at your door wanting to conduct a search. So, in essence, even though there is so much emotion and fear involved with this, my recommendation is to be polite and professional. You really you don't want to escalate matters for either yourself or for your business or your employees if you act with contempt or rude behavior or aggression. I think that if you follow some very simple steps, you can avoid a lot of this the scariness of the interaction. And I think that the best way to start with that is to train everyone in your business how to respond if someone shows up. My comments have been that, you get that knock at the door. It might not be a knock at the door. It could be somebody in the parking lot. It could be somebody coming through the back door. It could be any number of things where you're not expecting it. And good practice is to have a set procedure where employees will direct the agents to an authorized ICE contact person at your company. And that way, no one speaks to the ICE agent except the authorized corporate contact with the company. And these people can be a president, a CEO, a CFO, some other officer, or even a human resources manager. And having two or three designated people will reduce the risk of having having no one be there to speak to ICE in the event that they show up. Every employee, regardless of whether or not they're an authorized ICE contact, needs to know that they need to direct any inquiries to the ICE contact, the authorized ICE contact. You do not want your employees speaking with anybody. You do not want your employees really providing any assistance in the event that someone's saying, "Hey, where's this person?" You want to have them directed back to that authorized ICE contact person. The authorized ICE contact person should then engage with the agent, but also contact the company attorney so that the attorney is aware of what's happening and they can keep the attorney on the phone and, in essence, bring the attorney with them through the process, have the attorney speak to the ICE agent if necessary. It is important that you make sure you're actually dealing with an ICE agent and you are allowed to ask for the agent's credentials, and you can record and save each agent's badge number and contact information to the extent that they'll give it to you, but it's certainly worth asking for. And as Jerry said, they're very often masked and unidentifiable. But if you ask for it, it's hopefully there's going to be a record being made of what's happening, and at least you can show that you've asked for their identity in the event that something goes south. Now, once you've done all this, there's really, I would say, pretty much three very basic scenarios that an employer would face when ICE shows up at the place of business. One is they have no warrant. One is they do have a warrant. And the other one is they have some other document that they try to use to trick you into allowing them to conduct a search. I'm going to try to address each one in turn. The first scenario is where there would be no warrant. ICE agents show up, they have no warrant, no paperwork. They just want to ask some questions. It's a little more informal, but in that situation, you do not need to speak with them or provide them with any information, and they're only allowed to go into your public areas of your business. And public versus private areas is kind of an important issue, and whether something's public or private dictates where the ICE agents are allowed to go, depending upon what type of documents, if any, they show up with. A public area is just that. It's open to the public, like a parking lot, perhaps even a dining area or a reception or waiting area. And these are all very fact specific. So it doesn't mean that every dining room or every waiting area is necessarily a public area, but it's merely an example of what might be. Private areas are absolutely not open to the public. They would require the business's express permission to enter, such as a break room, a warehouse floor, a kitchen, a restroom, something like that. And the key distinction here is that the entry into a private area would require permission from the owner or the officers of the business. And if there's any questions about whether or not an area is public or private, definitely talk to that attorney. Hopefully he's still on the phone with you, and let him know what the question is. So the second scenario would be if they show up with a warrant. And with regard to warrants, Jerry touched on this. There are two types of warrants that may be shown. There's a judicial warrant and what's called an administrative warrant. And the first PDF that's in the chat is a sample of the federal judicial warrant. And you guys can click on it, download it, and have a copy of it for your records. Give it to your own clients and let them understand what they're dealing with. So a judicial warrant is issued by a court and signed by a judge. If you have a valid judicial warrant that's presented to you, you have to comply with it. That being said, you should take as many steps as you can to verify the information that's in it. A judicial warrant, if you look at what's been posted, it should include the following information: the time frame within which the search must be conducted, the name and the address of the business that's being searched, description of what may be searched, because it doesn't mean that they can start dumping out every drawer and popping open every ceiling tile. There's an area where they're going to be able to search. There's going to be a list of the items or people to be seized and the judge's signature and date. If any of these items is missing, it's not a valid judicial warrant, and you are within your rights, subject to what Jerry may say to ICE, hey, you're missing some information from this warrant, and I don't think this warrant is valid. And that is something, again, that the authorized ICE contact who is going to be in contact with the business attorney should address, not somebody else. If the warrant, however, is valid, you must comply. Compliance does not mean that you have to speak with the agents or assist them in what they are doing. And so it's an important distinction. Just because it's valid doesn't mean you need to help them hunt somebody down. They have to do their own work. The company does not need to answer any questions or provide any information, but they must allow access to private areas if that is something that's called for in the warrant. Now, the next two PDFs that are in the chat are examples of what's called administrative warrants. You'll see that neither of these administrative warrants are signed by a judge. Instead, what they are is they're signed by the ICE agents themselves. If you are shown an administrative warrant, you are not required to speak to ICE or assist them. The company does not need to answer any questions or provide any information. You are not required, unlike the valid judicial warrant, you are not required to allow them into any private areas of your business. They can enter public areas, but you are not required to allow them any other access. It's conceivable that they would show up with something else. And that's most commonly, I think, you'll see what's called an I-9 notice of inspection. And that's the fourth PDF that's in the chat. An I-9 form, I think everybody probably knows this. It's used by employers to verify a new hire's identity and the legal authorization to work in the United States. To properly complete one, the employee is required to show documents like a passport, driver's license, something of that nature. And the employer should be confirming these documents, but they don't always do that. The I-9 audit or notice of inspection is, in essence, it's an investigation regarding potential illegal or undocumented activities or employees at your business. Before an I-9 audit can take place, they first have to give you 3 days advance notice. So they can't just kick down your door and say, hey, we're looking for all your records, give us all your I-9s. They've got to give you some advance notice. So upon receipt of that notice, you should immediately contact your attorney, the business attorney, to discuss, provide a copy of the notice and discuss it with your attorney. The notice of inspection, it's not really a form per se, although I've given you a form. It can be just a letter. It's not as formal as a warrant. But again, it does require that you have 3 days advance notice before the audit is conducted. If for some reason the business wants to waive the 3-day notice, they can, but they don't have to. When receiving a notice like this, the business is required to allow reasonable access when the audit is being conducted. But the business is not required to provide access until after that 3-day advance notice period has expired. So put another way, if they show up with a notice, you can say, great, come back in 3 days. And that should be the end of it because they know that that's what the rules are. Now, if they don't, again, you should be on the phone with your attorney and your attorney can provide counsel. I will say anecdotally, I have seen a lot of and talked to a lot of people that have been impacted by this, their businesses, that have been impacted by this. As Jerry was saying, I think Gio was saying, people are not coming to work. And it's not necessarily that they're undocumented. It's just they're afraid that they're going to be targeted because of where they come from or what they look like. And so it's sending ripples through certain industries, certainly the construction industry. That's one that it is being felt. So yeah, it's a tough time for a lot of people for a lot of reasons. And hopefully this provided some assistance for the folks that counsel business owners like myself.
Thank you, Adam. Just a reminder, there's materials in the chat box if you guys want to download them that Jerry is kind enough to provide to us.
And mine, just for what it's worth, they're the first things in the chat, so you'll have to scroll all the way up. If you couldn't find the examples, they're the first four in the chat.
Let's see, I want to do something here. Let me get it set up. Come on, Georgie. Sorry for the dead space. All right. Our next meeting of Lunch and Learn is January 14th. We're going to talk about cryptocurrency for lawyers. So this is probably a timely topic, and given, gosh, what's going on with cryptos right now is just amazing, especially with the government basically deregulating it. If you guys want CLE credit, send an email to attendance@nwsba.org. On the subject line, put down "Thank you, NWSBA." Include your name, ARDC number, and the title of the presentation, and you will get CLE credit.
And you'll also get good karma credit if you're not a member and you sign up.
That's why we're doing this, Adam. Okay, with that, I'm going to stop sharing and invite anybody who's on there on to join us. Anybody want to add anything? I can't believe, Paul, you haven't added anything yet. Paul Plotnick, you always want to talk about something. You're on mute, Paul.
Yeah, I know. But I was worried about, well, what happened to those people that just got all sent to San Salvador? What happened to them? I mean, I don't know if they were criminals, they were just people they picked up off the street, and they're in jail down there. What's going on with that?
I don't know. I don't know if Jerry or Adam do.
Yeah.
Yeah.
Hi, Paul. Yeah, so I don't know exactly what's going on with them, but usually that there's going to be multiple rounds of appeals. Last I heard, I think they were trying to appeal that again, or somehow they weren't following the order that the Supreme Court gave. If I'm understanding correctly, the individuals that you're talking about, I think that was centered around a Supreme Court case where somebody was wrongfully deported, sent to El Salvador, and he happened to have lawful status and not brought back. Was that who you were referring to?
Well, that's one of them, but they sent lots of people. It was on the news. They sent them to jail there, and they're, as far as I know, they're still in jail there.
Well, maybe
some
a black
of
hole.
them, if they didn't have lawful status, or maybe they had an outstanding deportation order, then they're not coming back. And a lot of times, I think in the news that gets mixed up, and we don't know all the facts or all the details. But if those individuals didn't have any legal status here, then they're probably not coming back.
I understand that, but we don't know anything more about it. They were just all sent to jail, and of course, originally they were supposed to be sent back to the country that they came from. But there were a lot of them that were on the news. They were just in their underwear and they were gone. Yeah, there was one guy that came back, and they're still trying to deport him, I guess. That's in court, but the rest of them, we've heard nothing about it. It's like the
Yeah, and
gulag.
unfortunately, those are the times that we're in, and the administration that we're dealing with, and the Supreme Court has signed off on a lot of this, and they may not come back for quite some time, and the government has said they're okay with that.
Yeah. All right. Any other questions? All right. I'm going to stop recording.